To begin with, business and immigration law updates. This is written, directed, and hosted by a famous attorney, Mr. Ramesh Khurana, from the Khurana Law Firm located in Rockville, Maryland. Alongside Attorney Khurana is his moderator, Attorney Kenneth Haber, who questions Attorney Khurana on E-2 treaty investors and applicable essential requirements. Let's join these two gentlemen in their legal dialogue.
Welcome. I'm Ken Haber, former Assistant United States Attorney and former Senior Attorney in the Office of Inspector General of Health and Human Services. This is the Capitol Forum, and we have with us Ramesh Khurana, well-known immigration attorney, clients international, national, across this country and beyond. He's here to discuss with us, to educate us today concerning the E-2 treaty visa and inform us what it's about, because it certainly has a lot of complications. Ramesh, welcome.
Thank you, and I'm really grateful to you for giving me a nice introduction. Really appreciate that.
Well, just minor compared to your accomplishments over the years. There are just so many.
I really appreciate it.
Well, we appreciate you. Can you please describe for the audience what the E-2 treaty visa, investment visa, is about?
Sure, Ken. Now, E-2 treaty investor visa. Now, this has become very popular recently because this is available based on a treaty between the particular countries and the United States of America. To give you an example, now there are few countries in South Asia, we can name them Pakistan, Bangladesh, Sri Lanka, and India is not included in that list. India is not a member of the treaty country for the purpose of E-2 or E-1 visa. And on our border, we have Canada, we have Mexico, and most of the countries in Europe. So, under this type of visa, now people can come and make investment. It should not, of course, be a marginal investment. It should be substantial investment in relation to the type of enterprise they are pursuing it. And once they purchase that business or they acquire the existing business, based on that they have to file a petition. Either they can file a petition back home in their own country, or they come and acquire the business here. So, we say that effective steps have been taken to implement the business plan, and then you file the petition for approval of E-2 visa.
Do you have to make the investment before filing, or can you make the investment after approval?
No. If you can make the investment before filing of the petition, it's much easier, because then you can prove one of the factors for consideration by the USCIS while they adjudicate the application is whether the investment is irrevocable or the funds have been committed or not. So, we handle in two ways. One thing is we say, okay, now if you are intending to invest $100,000, why don't you invest at least $50,000 now in the business? If you are buying 51% of the equity of the business, invest $50,000 now and $50,000 place in the escrow account with your attorney, so that we can say that this is an escrow agreement, and when the E-2 petition is approved, the funds would be disbursed only to the corporation for which E-2 petition is being filed. That way we can prove beyond doubt that this is an irrevocable investment, or else you can put 100,000 altogether. It is very difficult if you do not invest and do not acquire some a store for the purpose of doing that business, or do not purchase some equipment, or at least I would say maybe you can place effective orders and you say, okay, I have placed orders for this equipment and these would be supplied after 3 months. So, again the decision will be made on a case by case basis.
Who may file for a change of status to an E-2 classification?
Can a person who is a national of the country with whom the United States has a treaty in regard to E-2 visa, let us say a person from Pakistan. he is visiting the United States, and after 3 months he finds some business, and he thinks that this is a business in which he would like to make some investment. But when he came here in the United States, he had no intent at all to make investment in this kind of business. Otherwise, it would become a fraudulent intent. Like he had this intent of purchasing the business and applying for change of status from B1, B2 to E2 visa. That could cause a problem. But if the intent changes, person can change the intent. If you find some good business opportunity, you say, well, I am going to make this investment. I never had thought about it while I entered the United States, but now I think that this is a business I always wanted to do it, and I got it. I would like to pursue it. So you file for change of status. You say, change my status from B1, B2 to E2 visa status. So you can file from here.
Can you tell the immigration officials in the very beginning, I'm coming over, I've always wanted to buy this type of business, I don't know if I'm going to find this type of business, I'm here for a visitors, tourist, business type of classification, and if I find this type of business, I'd really seriously consider it, so they know you didn't have any fraudulent intent?
Sure. I think that's a good idea. You can tell the CBP officer at the port of entry when they ask you, sir, why are you visiting the United States? So you will say, okay, I am here to find some good enterprise, good business. So they will say, okay, we understand that. And after you have found the business, there are two ways. Either you go back and apply from your home country, or else apply from here.
And you've established that you're not being fraudulent by telling them up front.
That's right.
Can a person, when they're first entering the United States on a visitor's visa, do that, or do they have to find a business to begin with?
Like I said, it depends. It's on a case-by-case basis. If you are entering on a visitor visa, if you have not found any business, but if you are intending to find a business, as you rightly pointed out in the previous question, better you tell the CBP officer, this is what you intend to do. Don't lie. Don't lie to that officer. And once you identify the business and you have taken significant steps toward implementation of your business plan for that particular business, and then of course, it's a question of transferring funds. We can talk about funds issue, and it's a very interesting and detailed topic. So you have to make sure that you transfer only legitimate funds from your bank account, and there should be a proper paper trail. And once you have filed the petition and you have proven these are legitimate funds, I'm sure the chances of approval would go high.
If you're outside this country and you have the money to invest, but you don't have the business identified yet, can you tell them that you'd like to come in on E-2 visa because you've got these monies available, here are the records that you've got this money, and you want to go looking for the business?
Not really, because the example which you have given Ken, he has got the money, he has got the intent to locate the business, but he has taken absolutely no steps to acquire the business or negotiate the business or have bought the business already. So everything is up in the air, except that he has got money, and still he has not been able to show whether the money has been transferred to his bank account or not, which is another important issue. I would suggest locate the business, find the business, and have your business plan ready. When you have the business plan, you have legitimate funds transferred to your bank account, and at that point of time, I think your situation is ripe to apply for E-2 visa. So but you cannot enter on E-2 visa, because if you are applying for E-2 visa back home in your country, then different consulates, they have their own procedures. Like Toronto consulate may have a different procedure what the UK consulate has. So you have to follow their procedures, and these procedures are beautifully explained on the websites of the US embassies. Follow those procedures. You have to register your business before you start filing other application, and then you have to go for interview. It's a very detailed interview, because officer likes to make sure before I issue E-2 visa to this person, whether he has got investment, and investment is coming from the legitimate funds, and the enterprise is not marginal. So, that is a profit making investment. And when we are talking about legitimacy of the funds, these are not only legitimate, these are his own funds, these are not borrowed ones. If he borrows money from one of his relatives or friends and he says, you know, these are my borrowed funds, but I am going to invest. No, E-2 visa does not work that way.
So it's best to come in on the B visa if you don't have the business identified yet. Tell them at the border that you're looking for a business, find the business, then make your preparations and seek an adjustment in status.
I think that's a better way. Yes.
That's interesting. I'm sure there's many people in the audience who would have relatives that over time would be interested in that type of understanding.
Well, I'm pretty sure, because people always look for some bona fide business opportunity, and this is one of the best options, especially if you are one of the persons from the treaty countries, and you could explore this option. And by investing, let's say 100,000, again, when I say 100,000, it depends upon the size of the business. If 100,000 is significant investment, when you keep that business in mind, let us say you want to come and open a restaurant, and you think that 100,000 investments should suffice for buying the assets of the restaurant. So, that means 100,000 is a significant investment. But if you are buying a motel which is going to cost you 1 million, and you say that I will raise a loan of 900,000 from banks, or I will get some credit loan from the seller, it is not going to work, because you are investing just $100,000 and investment in the enterprise is $1 million. So, it cannot be termed as a significant investment in the enterprise.
So it has to be in proportion to the nature of the enterprise.
That's right. This is how it will be decided and adjudicated whether the investment is significant or not.
What's the concept of irrevocable commitment of funds?
Yeah, Ken, when we are talking about irrevocable commitment of funds, that means these are fully invested. In our previous question, we talked about taking loan from somebody. If you are taking loan, then this is not your own money, and you are not committing it because you want to withdraw as soon as possible to return the loan. You know, this should be our own equity. And when we say commitment, that means funds should be at risk. Either you could lose it partially, or you could lose the total amount. So, if these are your own funds, only then you could afford to do it.
If it's a loan from an uncle, it's no good. If it's a gift from a parent,
that will work.
That will work.
Yes, gift is an irrevocable transaction. So, once a father gives a loan to his son, so gift money becomes his money. In fact, we have done certain transactions like that. When people want to gift money, it's acceptable.
I imagine the source is very, very important, understanding how it's going to be viewed by immigration.
That's right.
Well, I'd like to thank you very much for coming again to the station and informing the viewing audience about the E-2 treaty visa. It's certainly an area that many people would have interest in, and thank you very much.
Thank you very much, Ken, and my pleasure. And I would like to advise the audience, as always, please discuss your immigration options with an experienced immigration lawyer so that you could realize your goals and missions. And thank you very much for being with us. Thank you, Ken.
Thank you.